I got a question. Maybe there's a lawyer who will see this video and they might actually love this idea, especially if they're a real estate lawyer, or they're going to cringe. I read normally, as far as law, I'm good with tax law because I used to work loss prevention. I was a upper management in loss prevention. I was the guy who went in and looked for people that were cooking our books. And I had 10 stores in 3 states and I think it was 7 or 8 counties. So I had to know all the county tax laws. I had to know these 3 state tax laws. I had to know. There's just so much that went into that. Outside of that, I understand constitutional law. I'm actually didn't go to college for it, but I am a constitutional scholar. I actually do understand the Constitution. I get into arguments with people all the time over constitutional issues. But I am a constitutional scholar. Moreover, I'm a constitutional historian. I understand why things that are in the Constitution were put in the Constitution. Oh, you ought to see the debates that come up, even between me and my police friends. I have a lot of friends who are cops. Well, not a lot, but I have friends who are cops. I have a fair number of. I have more friends than most people when it comes to. My best friend is actually a retired NYPD decorated. It's my best friend actually. But you ought to see the conversations that I get into sometimes with my friends who are cops when it comes to stop and frisk laws and why the Fourth Amendment was written. Because historically, what they say and what the Fourth Amendment is actually about, one of the things the Fourth Amendment is actually about, is actually stop and frisk. The stop and frisk is why we have the Fourth Amendment. People don't understand that leading up to the Revolutionary War, the British were stopping and frisking the colonists to be able to take the guns because they knew the revolution was building up. People don't know that. People aren't taught that anymore. But that is one of the things that led to why the Fourth Amendment exists. That's why you are allowed to travel with your papers and your persons and your belongings and things like that. That's what the Fourth Amendment protects. One of the things it is directly meant to protect against is stop and frisk. Not talking about where somebody's committing a crime and they get stopped. Talking about where you're just walking down the street in the middle of the night, going to the convenience store, get a 40 or get a blunt or get a Coca-Cola or get a Pepsi, whatever it is you're going to get. You are allowed to walk to that store and back to your home without being subject to search, unless you're committing a crime. That's why stop and frisk is unconstitutional, despite what the Supreme Court said. I know what the Supreme Court said. The Supreme Court did not look at it in the historical content. But that said, that's just one example. But that said, I recently read a case. I actually sent this to a lawyer. I'm waiting to see if they reply or do a video about this because I asked a question. I read a story. It took place in Delaware. And it involved squatters' rights. An individual inherited some property from his father. And he intended on selling the property. He found out that he had somebody, they had a goat or something, a goat pen or something on the property. So that falls under the squatters' rights in that state. I don't know if that's the same for every state, but that in Delaware, just having that goat pen there, and the fact that she grew up thinking that that was her backyard. As a kid, she thought that was her backyard. So, the state of Delaware took a heritage property, meaning this belonged to more than one generation. This belonged to the father, and the father left it for the son. So it's a heritage property. It's gone through 2 generations now. Once you go through multiple generations, it becomes heritage. It's family heritage, but it's heritage. It's a family heritage. You have to go through more, I don't know what the amount of generations you have to go through for it to become a what would they call that? A public heritage. I don't know how many generations it has to go through before it becomes that, but no matter what, it's a heritage property, a legacy property. It's been handed from one generation to the next. The court just took the man's property and gave it to the individual who was technically squatting on his family legacy property. Before this all happened, the man, when he had intentions on selling the property, tried taking legal action to get the squatter off the property. Let's say you buy a piece of property, and then you find out there's squatters on your piece of property. And so you know now selling your piece of property is going to be a problem. Let's say your piece of property is worth a lot of money. Let's say it's in a desirable area. So you can actually use that piece of property to get a loan. So you get a lien against that property. If they make you sign over the rights after you've gotten a lien against the property using a loan, let's say in this case the property was worth $100,000. Let's say the guy got a $85,000 loan. He was able to get an $85,000 loan against the property because the bank knew that, they still have 15% interest in the property from the very get-go. So you got an $85,000 lien against this property. And then the court makes you give this property to her. Since she's taking possession of the property, and she's taking possession of all the rights of the property, doesn't she take possession of the lien? I mean, it's like buying a car. If I buy a car that has a lien on it, the only way for me to get that lien off, well, there's 2 ways. One, I buy it from the owner who has the lien on it. Let's say the car is being financed. Let's say it's being financed through their local bank. So I buy the car off them right there at the bank. They pay off the balance on the lien, and I get the lien release note. That's one way to get the lien off. But let's say I go to an auction and I buy that car. If I go to the auction and I buy that car, the state is turning the property over to me. But by turning the property over to me, I am now liable for the lien if I want to do anything with the car. I can't sell the car until the lien's off the car. Which means I have to pay the balance on the car. So let's say I went and I found a Dodge Demon. $100,000+ car. Has 2,000 or 3,000 miles on it. And I walk out of the auction with that car for $15,000. It's one of the ones that just slid under the radar. So I walk out of there with that car for $15,000. Then I find out the lien on the car, there's still $90,000 in the lien. It means I pay $105,000 for the car in the end in order for me to do anything with that car. So why can't you do that with real property, real estate? If you know you got a squatter on your property, and you know there's a chance that the court is going to make you give that property to the squatter, why not, as an insurance policy, you take a loan out against the property? You don't spend the money you get from the loan. You just take a loan out against the property. You set that money in a CD. Let's say a 3-month CD, or if you think this is going to take a year, then you set it in a 6-month CD, so that every 6 months you can roll over the CD with the money that it makes. But you also know it's only locked up for 6 months. That's why I like 3-month CDs, because they don't lock money up for a long period of time and you still make an interest on them. In a case like that, you put it in a 3-month CD, and every 3 months you're rolling it over. And you get your property back. You don't lose your property to the squatter. That means you can pull the money out of the CD, you can pay the full balance off on your loan, you might have paid a little bit of interest along the way, but in the end, you still have your property, and you have no lien on your property. But if it goes to the squatter's responsible for the lien now. Basically, they bought your property, because now they have to pay the lien, just like you do with the automobile. I mean, wouldn't it make sense that's how it works? Or, let's say, because the squatter can't pay back that lien, now it goes to an auction, and now you got $85,000 sitting there that you could play with to auction on your own property and get your old property back. Because the squatter lost the property because they couldn't afford to pay the loan back to the bank. So the bank repossessed the property from the squatter. So now you got $85,000 for your property. Granted, you might have lost $15,000 on the property, but you got $85,000 for your property. The squatter, because they can't afford to pay the lien, they lose the property to the bank. The bank takes possession of the property. They get the individual off the property. Then they take the property to auction. You might walk away with that property for $35,000, which means you made $50,000 on a property before you sell the property. Because the reason you're buying back the property is because you know you can sell the property. So you buy back the property for $35,000, which means you still have $50,000 profit in your pocket. You sell the property for $100,000. You made $150,000 on your piece of property because of a squatter. Isn't that possible? I mean, as long as you put the lien on the property before you start going through the legal process, no one could prove you knew the squatter was there. You find out you got a squatter on your property, you put the lien against your property, you get the loan against it, you wait 3 months, then you go and you start, oh shit, there's a squatter on my property. And you go through the process. Isn't that possible? I'm just curious. I'm sure there's a lawyer out there, real estate. Actually, real estate lawyers might really love it. They might be like, holy shit. I'm sure there's a couple of real estate lawyers out there right now that they're working, trying to figure out how the hell they can help this property owner that wants to sell the property, and there's nothing they can do, and they're like, well, what? And so now they know if this would work, if this would actually be legal, now they know. They tell the property owner, hey, before we do any process with the squatter, this is what we're going to do. And then you just put them, and like I said, the thing is, you're making money on your CD also. You got 85, what if it's a $200,000 piece of property? What if it's a $500,000 piece of property that the squatter's on? That's a lot of money to make in interest while it's all going through the process. So to lose a little bit up front, but to be making extra money on the backside, because in the end you're going to be able to get your property back through an auction unless somebody goes stupid crazy and decides, it's a $500,000 piece of property and they're going to pay $600,000 for it. Of course, you're not going to be dumb and do that. You're just going to take the little bit of loss that you had. Let's say it was a $500,000 and you got $475,000 for the loan against your property. Take the $25,000 loss. You made out good. And you screwed over the squatter. So, for the person who was trying to steal your property, when you're only paying a small percentage to get revenge, I think that's great. I'm just wondering. I mean, like I said, this isn't constitutional law. This is actual legal basis. So I'm not sure how that would work. But I'm curious. Would it work? Is there a real estate lawyer out there that can answer that question?